All right, so this is what the document looks like. We're actually going to spend most of our time looking at the actual residential listing agreement. This is a summary of what the major changes were that were made in the December 25 form release. And we're going to actually look at some of the new forms that, well, there's one in particular that is now sort of hardwired into both the residential listing agreement and also in the residential purchase agreement. And the digital photographs is one of the things that has changed. There are a bunch of other small changes that were made, and this is what the form actually looks like. The parts in red are the parts that have been modified. And what I want to do, however, once I find the right tab, here we go, is we're going to, do I already have it open? So I like to do this in zip forms, but to actually go through what you would go through using my sample. All right. Now, and I haven't put in all the information, but for those of you that have watched me talk about zip forms and purchase agreements, the things that I mentioned that will save you a lot of time, and if you're on my team, the transaction coordinator will help you create templates. But the template would be your information, your DRE number, your broker's information, your broker's DRE number, your broker's address, and some other information. And if you create a template with that, then you don't have to put that information in manually every time. You can see I have more templates than most people do, but there's listing templates and buyer templates. And Angela, if you could watch the chat, if there's something I should talk about, just, don't be shy.
Of course, Erica will have to.
I'm not worried too much about that, but just so notice I already have them for the different, I'm an affiliated broker for all 4 of the California regions with EXP. So you can see, and each one has its own DRE number, its own address, all of that sort of stuff. So if you create a template, you don't have to fill that in every time. So let me just pick which one. How about this one? Right? How about that one? We don't need 2. So that's the first thing you'd want to do, is to make sure you have buyer and seller templates. Now, if you're writing an offer, you would want to import the information from MLS Connect. However, if this is a listing appointment, it's probably not in the MLS, because that's why you're going to go talk to them. So what you would do instead is use Record Connect. And the property, this is a made up property, so you can't really, it's not going to work. But basically, Record Connect is looking at the public record database. And if you wanted to see another version of that, even though the property is not in the MLS, let me see if I can find one that, I don't know, I'll pick this one for just fun purposes. All right, so even though the property is not in the MLS, if you find a property in RPR, doesn't it look beautiful, and you scroll down and keep scrolling, you'll notice that there is an icon of a howling wolf. That is the lone wolf, which is what the company that makes zip forms is called. And if you click on that or click on that, what it's going to do is it's going to import the information that's in the public record. That means who owns it, is it a trust, is it not a trust, into zip forms. However, the part that works best is that if you use Record Connect. And the reason that Record Connect works a little bit better is that a lot of times the first name, last name, all that is all jumbled up. And you can sometimes guess, well, that's a first name and that's a last name, but they're not necessarily in that order when you look at the public records. And Record Connect allows you to pick, because it gives you a variety of choices, first and last, and you can pick which one makes sense. and it imports the information into the system. So let's say you've done that, right? You've got, and now the other thing you'd want to include in parties. So if you go to parties, you're going to want to have the seller's information. And if, let's say it's an LLC. So for example, if the LLC is MD Group, and this I know looks weird, but let's say that's your LLC, you would put it in something like that, in the first name, middle name, last name. Now, obviously, or if it's a trust, you would do MD Group Trust, and then you'd put in whether you fill out the rest of the information at this point, if it's an LLC or a trust, is not that important. And the reason it's not that important is because the LLC and the trust can't sign anything by themselves. So down here, you would put in the name of the signing representative, like who is going to sign, and you'd put in their email address. And so what that does is it auto-populates the trust or the LLC in all of the boxes that say name of seller, but then it'll put in the person who is authorized to sign for the LLC or the trust in the specific part. What if you have two people that are supposed to sign? Well, this would be seller one, the other one would be seller two. If you have more than two, it's a pain. I'm just telling you. There is a form called an additional signatures addendum, which I don't want to go into. At some point, I'm going to do all the different forms, right? Just for fun. But right now, we're going to hopefully only have one or two. So then we're going to look at the different documents, and we're going to start with the residential listing agreement. And I'm going to spend some time when we get to the parts that are changed. You would, because I put this in, I don't know why I did this, but let me, I don't know why. Let me try this. eXp Realty of California, Inc. That's the right DRE number. It's got my name, my DRE number. You just check the box, because I look at a lot of these. And what do I look at? I look to make sure they check the right boxes, right? If there's two sellers, that they're both checked. The broker is the correct broker. Sometimes I have agents that don't really know who their broker is, right? They are in eXp Realty of Southern California or eXp Realty of Greater Los Angeles, or they're not really sure. You might want to know that and make sure that you have the right template, because it'll cause trouble later when you're telling people you work for the wrong broker. Date prepared is, like it sounds, the date that we're preparing the listing agreement. It is not necessarily the date that the listing agreement is going to be signed. It is not the date that the listing is going to be on the MLS. It's none of those things. It is the date that we're preparing it. Is that an important date? The answer is yes. Why is that date important? Because all of the other documents that we're going to be using, like, for example, the RAD or other documents that are related to the listing, are going to say the residential listing agreement dated, and that's the date that they want to see in all of those other forms, so that we know exactly which residential listing agreement we're in fact modifying. Situated in Morgan Hill, Santa Clara, why not? Zip code, parcel number, it's good to put it in. The reason is that it might affect, it's sometimes more descriptive. I've had sellers argue that a particular street address is the legal parcel that they own. And I'm telling them, actually, that street address is not the legal parcel. And they're saying, well, of course it is. Look at the post office delivers mail here. And I'm like, that does not make it a legal parcel, right? Because if you wrote on near the mailbox A, and then another box that said B, they'll deliver it. but that doesn't mean it's a legal parcel. So the assessor's parcel number is something that is a little more official that identifies the parcel. How would you get that if you used RealConnect to import the information into the property? It's going to be there. If you looked at RPR, the Realtor's Property Resource, which you ought to have done, and pulled up the property, it's going to be there. Now, you always want to check the public records when you're filling out a listing agreement. This has happened to me. Now, I've been doing this for a while, but this has happened to me several times where the person I've been talking to about listing their duplex, when I actually pulled up the public record, their name is not there. Or their name is there, but there's somebody else's name that's also there. And then that raises the question, who are you? If your name isn't even on the public record, who is this whose name is there? Who's the other person that is on the public records as one of the owners? This happens more often than you would think. And one of them, the person said, well, that's my brother. I've got it in his name for whatever reasons. He'll sign everything. And I was thinking, so what do? Do you take the listing, putting in the brother's name? Because the sister says he'll, I took it because I'm a typical greedy real estate agent. And he signed everything and showed up and signed off. And I sold the listing. I sold the duplex. So, but you understand, you got to look just to make sure that whoever is signing is actually some of the owners. Listing period, you would begin it today. Now, one of the conversations you often have to have is because the owner may say, well, we don't want, it's not going to be till like February 15th that we're going to be ready to put it on the market because we've got somebody's moving out and we're going to have it cleaned and painted and fixed up. And so let's start on February 15th. You don't want to do that, right? What you want to say to them is, look, there's a difference between when we're marketing your property and showing it and when you hire me to go to work for you, because there's all this prep work that I need to do. I need to open up escrow. I need to get a copy of the preliminary title report. I need to start collecting all the disclosures that we're going to need. And I can't do that unless you actually hire me. So you're going to be hiring me today to represent you, but you'll see later, we're not going to put it on the market right away. We're not going to show it right away. That'll happen in February when you're ready. How long can it be? Notice it says not to exceed 24 months. That's a long time for a listing, right? Have I ever taken a listing for that length of time? The answer is yeah, once. Right. The people that owned it, it was a property in Sunnyvale. I had sold the sister a house. I sold the mother's house. I kept asking the sister, what other family members do you have? And her brother had this property and he wanted a certain price. And he said, I know, I'll just wait it out. So I listed it for like a year and a half. Every agent in the office got to do open houses because, and the market kept going up and eventually it sold and I got paid. So normally it's what would be a common in a normal market length of a listing, it would be about 90 days, right? That would be common, right? And you would, of course, want to know what days on market look like. You would also want to know whether or not the price the seller is looking for is in fact reasonable, right? Because we may take longer if it's an unreasonable price. Oops, that's not what I wanted. How about this? All right, just for fun. Now notice if it is a LLC or partnership or a corporation, the listing can be for any length of time. The 24 months, the 2 years, is just a statutory maximum. I know you may find this hard to believe, but there were agents that wanted to have a unlimited listing. Now, part of the challenge of doing that, because they would just leave it blank and hope that they would sell it, is that there's a California Business and Professions Code section followed up with a Department of Real Estate Commissioner regulation that says that all exclusive listings, which is what this is, an exclusive authorization and right to sell, all exclusive listings have to have a definite final termination date. And if you write up a listing and you don't have a definite final termination date, not only is it void under California law, but you could be disciplined by the Department of Real Estate if somebody ever complained about you. All right. By the
My,
way, go ahead, question.
somebody's asking, would the end date be 2027?
It could be, but usually people don't want to list the property for that length of time. Most sellers will go for 90 days, but it's difficult to convince them you need a year.
Michael, I always do 6 months to a year because it's not so much for the seller, but it's for other agents contacting. And, like if you put a 90-day, well, on the 90th day or the 91st day, every agent, their brother that sees it's about to expire starts calling. So it gives a little cushion and protection, even though we don't necessarily need that much time for our listings in this area. Just a thought.
That's an appropriate thought. My thought is that by the time it had hit 60 days, I would be discussing a price reduction and an extension. Just saying, right? It depends on your market. Cool. By the way, exclusive authorization and right to sell. What is a listing agreement? If I list my home, am I offering it for sale? Is a listing an offer to sell real estate? What do you think? Oh, come on, somebody must have an opinion. That seems like a pretty straightforward question. Is a listing an offer to sell real estate? Well, don't everybody blurt it out at once. So the answer is no.
Yes.
The answer is no. And if you're wondering why, is the answer no? Because if we're using the term offer in a legal context, which we're talking about a contract, an offer is something that legally can be accepted. So if I have a listing and Warren Buffett were to come to me and say, hey, I hear you have a listing on this property, can I see it? And I showed Warren Buffett the listing and he says, looks good to me. He takes out a pen and he writes at the bottom, I accept, dates it. His chauffeur, I don't think he has one, but his chauffeur is a notary and stamps it and says, we'll be back tomorrow with the money. Have I sold the property? Right? I called the owner up and I said, you won't believe what happened. Warren Buffett just came in. He just bought that property you own. And the owner says, what do you mean he just bought the property? Apple just called me and they're offering me millions more for it. Has the property been sold? And the answer is no. And that's because a listing is not really a real estate contract. It's an employment agreement, employing the broker to conduct personal services. It's not a legal offer. What a listing is a bilateral contract. That means two promises, where the owner promises to pay a commission. What does the agent promise to do? Does the agent promise to sell the property? Is that the agent's promise?
Yes.
So if you don't sell the property as the agent, you are in breach of contract and you can be sued by the seller. No. So we don't promise to sell the property because we'd be sued if we didn't. We promise to use diligence. We promise to try to sell the property. Now that's a much lower bar. Why then do we call it right to sell? Is it a power of attorney? And what's confusing, if you think about this, and maybe I've thought too much about it, is that it doesn't give anybody the right to sell anything. So why do we call it that? We call it this to make it sound more serious to sellers. They're giving us an exclusive authorization and right to sell the property, but this at this point it's simply an employment agreement where we promise to try. I think it's important that we know what the contracts we're using actually mean. So list price, let's say, how about that? It's a nice little home. Property specifics. Now, the new versions of the California Association of Realtors forms, when you check appropriate boxes, it launches another document. So if this was a mobile home and we check the box, we use the same listing agreement, but now there's the mobile home addendum that would pop up. And if it's a probate, conservatorship, guardianship, and we check that box, then the probate listing addendum would pop up and it would be added to the property, to the listing agreement. Paragraph C is what I refer to as the magic words, because the California Civil Code says that any agreement to pay a real estate agent a commission in order to be enforceable has to contain certain words. It doesn't say magic words, but certain words. And those words are: the amount or rate of real estate commission is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Now, there's a form that, notice, you can't check or uncheck. It's the compensation advisory hardwired in. By the way, the Civil Code says that this notice has to be in Helvetica or at least 10-point boldface type, right? You can't have some weird script that people can't read in little tiny. It has to be certain. And so all of the compensation agreements that the California Association of Realtors has this statement. Compensation to seller's broker. Let's just say we're doing 2.5%. If it could be, if any, what would the and if any be? Sometimes listing agents charge the seller a additional transaction coordination fee, right? That's where you put it in. Could you charge a flat fee? Yeah, you check the box. Could you have an attached compensation schedule? Sure. What would that look like? Well, sometimes sellers say, if you get me this price, I'll pay you this much commission. But if it's only that price, then it'll be this much commission. Not a very common thing, but there it is. Additional compensation if seller's broker if buyer is unrepresented. Now, what that means is, what if a buyer, I'm the listing agent, and a buyer contacts me and says, look, I don't have an agent, but I want to buy the property. Now, the conversation to have with the seller is, do you want me to be, in a situation like that, a dual agent? And when they say, well, what do you mean a dual agent? I say, well, it's kind of like a double agent. If you watch the James Bond movies or something like that, the double agent is working for both sides at the same time. Do you want me to be representing the buyer or just represent you exclusively? And most of the time, the seller is going to say, I just want you to represent me. I don't want you representing them. Okay. So do you want to, and by the way, something I point out to sellers is that over 70% of all the litigation involving real estate is when there's only one agent in the transaction. So if the buyer doesn't have their own agent, they have a stronger case to sue us because they're going to say, I didn't have an agent, you guys took advantage of me. Do you want to even accept offers if the buyer is unrepresented? Sometimes they say no. Actually, now that you mention it, I would rather they have somebody, because that other agent, the one that represents the buyer, has errors and omissions insurance. That's who the buyer would sue if it gets screwed up. But if we don't have a buyer's agent and it's just me and you as the seller, then we're the ones that are going to be sued. And sometimes they'll say, well, I don't, I want them to have their own agent. Sometimes they say, well, I don't really care, right? I'll take the risk, go ahead and let them buy the property. Now, the challenge is going to be that that buyer, if they don't have an agent, doesn't have a copy of the purchase agreement, doesn't have a copy of all the forms, and I'm going to have to help them with that. Now, I can help them without being their agent, but if I'm doing that, I want to be paid more, because I have to do, and we even have a list, I forget, it's 104 things that a buyer's agent typically does in a transaction. And the 2.5% is for me to represent you. If I'm working with a unrepresented buyer and having to do all of that for them, I want additional compensation. How much? Whatever you want to put in. I know agents have put in another 2.5%. But notice it says it does not apply to dual agency. So what's the difference? Well, let's say you have a buyer representation and broker compensation agreement with the buyer, where the buyer says, I'm going to pay you 2.5%. And you have a listing agreement with the seller that says the seller's going to pay you 2.5%. You're a dual agent. Now, you have to disclose that to both parties, but it's not illegal or unethical. And if you're at EXP, we allow you to do it. Not all brokers do, but there you go. Any questions about that?
Michael, in one of the other trainings, not yours, but someone else said, you can put in, you were saying you have to help them with the forms. Debbie was saying that you have to provide them the forms, but that you don't have to help them. Now, if they put an incomplete offer in, then you have to counter back. So you're right, it does cause a lot more work.
Yeah.
But we also, as agents, can choose not to be a dual, agent.
Right.
Which is like, I don't do it myself. But the thing is that I don't put down anybody that does do it. I just prefer not to because of all the legal ramifications.
I understand. And by the way, the next time this comes up, feel free to refer the buyer to me.
I would love to, what Debbie has said, I used to just do, a couple. She said it's best to go ahead and just maybe 3 or
Right.
4.
But
So,
Debbie, for
and
those of you who
put,
don't know, is the senior managing broker for EXP. I do understand the argument legally, because I listen to C.A.R. lawyers a lot, that they can, if we're not acting as their agent, they have to figure out the form on their own or show it to a lawyer. But I'm talking in a more practical thing, we would probably be writing the offer. Don't tell Debbie I
so
said.
you do, no, I wouldn't do that. So you're saying you would go ahead and write the offer with
Yeah,
them?
yeah,
Okay.
I would.
And Michael, I wanted to clarify just real quick before you move on. Before, when you were saying 3 months, the reason I was thinking for the listing time, that is the period of time, and it can be extended. But the thing is if you take a listing and let's say the property's not readied, I had one, usually they're readied quickly, but I've had one that the listing agreement was signed September 2nd, and we're going to market in March. So we would have had to, I've already had to extend it once. So I'm just saying a 6-month on there or a year isn't really the time. It just kind of gives you, how would you say? It gives you the opportunity or the option to have that. But you're right. In our areas, the
It's a
listing
good point to make. Obviously, the time period of the listing would be adjusted to reflect when it's going to be ready and put on the market. But what I'm saying is if it's going to be on the market, 90 days is usually enough. But if it takes 6 months to get there, then it would be, longer. Paragraph C3. This is what historically has been called the broker safety clause. It's a clause that says, so let's say it's 90 days just as an example, and it is day 89. And you've showed the property to some buyers, and they're like, we're interested, we're really thinking about it, we're going to let you know on Monday. Well, Monday means it's past the 90 days. And then they might drive by the property on Monday and they'll see the for sale sign is gone. They go up and they knock on the door. And when the owner answers the door, they say, hey, what's going on? We saw your property just last week and, you know, it was for sale and we're interested in buying it, but your sign is gone. Do you still want to sell? And the owner says, well, as a matter of fact, I still do. Come on in, let's talk. So what the safety clause or the continuation period, as what it's called now, is that if you, and you have to give the seller a list of the people that you've been negotiating with for the sale of their property. And if any of them were to buy the property in the next 90 days, it doesn't have to be 90 days. You could put in 6 months, I don't care. But if any of the people on the list buy the property within that time period, you get paid the commission. Have they had the property on the market before? Did they really cancel or did the listing expire? Did the previous listing agent give the seller a list of names, like in C3, of people that they were negotiating with? And are we within that time period? That's what C4 is about. Does the seller have any obligations to pay another broker for particular buyers? If so, this is where you would say who the previous broker was, and if he said, well, yeah, they gave me two names of people that they were negotiating with, that's where we would write them in. This is one of the big changes, is the broker is paying a referral fee. And then that brings up the C.A.R. form, RAD, which we'll get to it. Items included or excluded, why not? What you put in the listing is not important. It's what's in the purchase agreement. But if they say, make sure that the chandelier, is not included, check the box, write it in. I would tell them to take it down now so buyers can't even see it. Go to Home Depot, buy a replacement, put it in a box, hide it. Any leased items, propane tanks, solar power, that's other issues. There's another class on that. Any liened items, which means that they still owe money. And again, you would check the boxes. Any smart home features, included or excluded. Are you going to take the Ring doorbell with you? Are you going to take any of the other security? That's where you'd write it in. Notice it says property will be marketed in the following MLS. Now, I'm a member of MLS listings: Santa Clara, San Mateo, Santa Cruz, Monterey, and San Benito County. But I've listed property in Alameda County. So there's really no difference because of the data share arrangements. But if I were to list a property, let's say in Tulare County, which I could do, I could put that in my MLS and I could write in Tulare County, I could put in an address and it would take it. But that's not the MLS for Tulare County, and our MLS does not share data with Tulare County, which means the agents in Tulare County, when they're searching the MLS, they will not see the listing. So you're supposed to tell them which MLS you're putting it in. Most people don't read it or care, but you would put in your primary MLS. Now, I'm a member of several MLSs. I don't know why, but I am. But not Tulare. And I could say, well, I'm also going to put it in MetroList. I'm going to put it in C.A.R. MLS, the MLS. I'm a member of all of those. And there's a form if they want to read about it. Publication of sellers' willingness to consider concessions. This is a conversation you should have with them, right? The comps, 95% of all buyers have their own agent. The amount of double-ended transactions is very, very small. Particularly if this is a first-time home buyer property, chances are they want to have an agent. The way I explain it to sellers is we want buyers and buyers want representation. and signaling that we're open to giving a concession to compensate the cooperating broker if they bring us a ready, willing, and able buyer willing to make an offer on a price and terms you like. If we're open to looking at those offers and providing a concession to cover the cooperating broker's compensation, let's check the box. And you need to understand, the seller, that when people are searching on the MLS, they're going to be able to see this or not. And if you say, no, I won't do it, never do it, first of all, you have to understand that all these comps I've been showing you for what your property is likely worth, they all pretty much had a agreement to compensate a buyer's broker. And I point out that new home subdividers who are not members of the MLS, not members of the Association of Realtors, never had to compensate cooperating brokers. There's no law that they said they have to do it, but they do it anyhow. Why do they do that? Why do new home builders cooperate with real estate agents? Because they're generous. They feel sorry for real estate agents. They're worried they don't have enough money to feed their family, or they've studied it because they do hundreds of thousands of home sales every month. They've studied it and they know that they get net more money if they cooperate with real estate agents. Maybe we should use that as a guide, right? And so it's not a question of whether or not the buyer agent is being compensated. The question really should be, how does the net from this offer look? Right? And so my recommendation, very strong, is to check that box and put in the MLS that we're open to consider concessions, make us an offer. By the way, are there buyers? This is the conversation I would have with the seller, is the difference between a retail buyer and a wholesale buyer. Are there buyers that don't need agents? Don't worry about this. The answer is sure. They're called investors. Now, an investor is not a retail buyer. They're a wholesale buyer. So if we're not willing to cooperate with other brokers who bring us offers, we're going to be stuck with the investors who generally lowball because they want to buy it wholesale so they can turn around and resell it and make money.
Mike, there's a question.
Uh-huh.
Do we need to fill the E1 others field with data share MLS of the primary
No,
MLS?
most times they don't look at it, so I would just do that. Now, they want to know, and if there's not enough room to write all the data share areas. So part of my listing presentation is I would show them, like in my MLS, there's a map of California, and it shows all the data share areas. And I show that to sellers if they're curious. That shows, look at it's the big MLS, C.A.R. MLS. It'll be there. It'll be in the big LA MLS. It's going to be in the San Diego MLS. It's going to be in the Sacramento Valley MLS. It's going to be in the North Bay Area MLS. It's going to be in San Francisco and Alameda and Contra Costa. The sea, all this is where it's going to go. And usually they don't even look at this or care, but if they did, I'd show them the map. All right. Seller instructs the broker not to take photographs except as required by MLS rules. Why would you do that if you were a seller? Because the property is so ugly that the more pictures you show people, the less likely they are to want to look at it. The MLS generally requires 2 to 3 pictures. It depends upon the MLS, or you can't put it in. And I've had such ugly listings that I took 3 pictures, one from the left of the front, one in the middle of the front of the house, and one on the right of the front of the house. So I had a minimum number of pictures, but showing people what it looked like was not actually going to help us. It was a teardown. But that's what that box is for. Timing of presentation of offers. Do you take offers as they come, or do we set a date? Now, there's pros and cons to both of those. The challenge with saying we take offers as they come is the fear that we'll right away get an offer and it has a short acceptance period. And we have to decide if we're going to take it or not. And if we take it, we might be getting a higher offer. Just in the next couple of days, it's already they're going, and we it's too late. We've already accepted something else. So depending upon the market, let's say in Silicon Valley, it's a very still competitive market, multiple offers for most of the time. So we might say, look, we're going to take 2 weekends, right? We're going to have 2 weekends where we do open houses. We'll let people show the property during those two. And then following the second weekend, and my preference, by the way, is not Monday. Right? Don't do Monday because the buyers that are interested are scrambling to get their letters from the lender and get all that together. Tuesday noon is when we're going to look at offers, Wednesday noon, something like that. And by the way, that noon means until like 4 or 5 o'clock sometimes, but it gives us time to let them come in. And then we can put in a date. This is the day we're going to accept the offers. Now, if you're an agent and you say, we want the offers on a particular date, right? And so let's say we're not going to take offers until this date, right? Or we could write in a certain number of days. You better stick to that. If you say February 10th is when we're taking offers and tomorrow you get a really nice offer, and you want to take it, and you take it, the other agents that have been waiting to the 10th can file an ethics complaint against you, and you will be disciplined by the Board of Realtors because this is considered unfair practices towards other realtors. If you say we want 2 weeks and then we'll take offers, you have to wait 2 weeks and then take offers. Just saying. And if you want to change this, can you? Yes, you could change the MLS. You could notify everybody and give it enough time, but does everybody understand the issue here? If we say as received, what if there's more offers we could get? The idea is we would like to get 5 offers, 7 offers, 10 offers, all at once, because the more people want it, the more people want it. Supplemental offer letters, these were called buyer love letters. Generally, it says as a default, don't present them. Or they could check a box and say, I want to see them. What's the downside is that a lot of times the buyer love letters, they would, like, for example, I had a listing where it was kind of obvious from what you would see on the walls and things like that, that the owners were a member or a participant in a particular religion. And so we started getting love letters from buyers standing in front of a similar house of worship, right? That's where the picture was taken, so that they're like going, pointing at the same sign. Now, the federal fair housing and California fair housing laws prevent making a decision as to who can buy the house based upon religion, among other things. And then the buyer love letters would have pictures of all the cute children, right? Nowadays, I think that they might use AI to create cute looking children so that they can have this, look at we're a family, we want to move in. Well, again, family status and children and stuff like that is not something that you can use as a determining factor. So the potential problem with this is that if we accept these letters and you pick somebody because you like them, and then it closes, and some of the other buyers who submitted offers checked later and they found out that you sold it to somebody for less, you're going to get sued. Right? You're going to get sued for violating federal and state anti-discrimination. Just saying. Generally, you notice the default is don't give us buyer letters. Investigation reports. I am a big proponent of getting all of this stuff, if it's relevant, upfront, because we want to put together a disclosure package. We want to be able to disclose any and all defects, material facts regarding the property. We want to be able to do that. It's way better if we have all the inspections and reports and we collect them up front so that we can get the buyers to make a non-contingent offer. But you're going to have to, negotiate that. I don't seem to have trouble getting all of these on my listings, but in the Silicon Valley area, 90% of the listings, they have pretty much everything. Right? We don't want them to be getting these things in the middle of escrow, them being the buyer, and then trying to renegotiate the price. Exceptions to ownership or title. How do you own the property? Do you own it as a tenant in common? Is it a joint tenancy? Is it an LLC? Is it a trust? Are there other people that would have to agree to do this? Because a listing is not a real estate contract, like a purchase agreement, but an employment agreement, it can be binding if one of the owners signs. However, the MLS rules say you can't put it in the MLS if you don't have every owner's signature on the listing. Because what will happen is one of them will say, well, I don't want to sell it, right? So we want them all to sign the listing. Now, just to be clear, the MLS usually does not see a copy of the listing agreement. Escrow doesn't see a copy of the listing agreement. The transaction coordinator, the broker, sees copies of the listing agreement. But you understand if there's somebody else, something wonky with the title, you would write it there. Contingency to find a replacement property. If you're checking that box, you really ought to think about it. If you're on my team, talk to me, because there's easier ways of doing it than making the sale contingent upon them finding another property to move to. When would that be more important? If it's a 1031 exchange, where you want, and then there's other forms that we would want included in the purchase, the seller's intent to exchange addendum as an example. But if it's a 1031 exchange and you can't find the up leg, you don't want to sell the first property. Lockbox, key safe, signs. These are good ideas because the more people that can see your property, if we can't show your property, we're not going to be able to sell it. And the more barriers we put between the buyer's agents and the buyers and being able to see your property, the fewer of them are going to see the property. And the chances are we're not going to get the best price possible. Additional terms, you usually shouldn't be writing anything in there. But, and if you're on my team and you want to write some poetry there, talk to me first. I'd be curious to hear what it is. We're not going to do REO. That's when it's a bank-owned property, or a trust advisory. If it is a trust, we would include the trust advisory. Short sale is if the value of the property is not sufficient to pay off the existing liens and closing costs. That means we need to get the permission from the seller. And then the rest of this is really stuff that you can read. Very few sellers really want to go through this. There's an explanation about preemptive offers, and if we say we're not going to do it, we have to not do it. All right. Buyer letters, good faith investigations, dual agency, potentially competing buyers, sellers concessions, etc. Now they've moved it around, so it will take me a moment to find it. But let me just see. I know what it says, but I'm not going to spend a lot of time It says in the residential listing agreement that if you're the listing agent, the seller has given you permission, has authorized you. Let me see if that pops up. To tell other buyers, I'll find it someplace. I'm not going to just search for it. There's a clause in the PRBS, the possible representation of more than one buyer or seller. It's also repeated in the statewide buyer and seller advisory, and it's in the listing agreement. It would just take me a minute to find it. But if you want to, go on what is it, a hunt, you could look for it. But what it says is that the listing agent is authorized by the seller to disclose the number of and amount of any offers received to other agents. Because, and I've had agents say, oh, no, I can't tell you, do you have offers? Yes, we've got 3. How much are they? Oh, I can't tell you that. It would be illegal, unethical for me to tell you how much the current offers are. That's BS. If you're the listing agent, your job is to get the best price possible for the seller. It's repeated several places throughout the disclosures that you're authorized to do this. I would. If somebody calls me and says, do you have any offers? I'd say, yeah, I got 3. And they'd say, well, can you give me an idea of how much they are? Top one is 1.2. Beat it, right? If you can. And then they say, oh, well, thank you. And they come in with 1.25. Some other agent calls me and says, do you have any offers? I'd say 4. What's the highest one? 1.25. Oh, well, thank you. Right. You understand now what I'm doing. I don't need lower offers. I just want to see if I can get more and more and more, and you can keep working them up. This is why if you're writing an offer, you don't want to give the seller too long to think about it. Because if there's an agent like me, they'll be shopping your offer, telling everybody what it is, and encouraging people to write a higher amount. Just saying, it is there. But I don't know where it is right now. All right. So the other form that I wanted to talk, this is you can read these, the MLS addendum. You can, seller instructions to broker about internet. If we're serious about selling it, we want it on Zillow and Redfin and Realtor.com and Homes.com and everything else. I'm not going to go through all this. Delayed marketing means that we're not going to be marketing it right away because we have to clean it and paint it and fix some stuff. If we coming soon is we're going to let other agents know that it's coming soon. MLS listings, my MLS has a members only, which is a form of coming soon. We would check that box. If it's an office exclusive with limited exposure, by the way, EXP's official position is it ought to be in the MLS to get maximum exposure, but we do have an EXP exclusives. This is generally for the benefit of agents, not for the benefit of sellers, but you would check the box. They begin marketing the property under full exposure on a certain date. This is if we're not doing it right away. We would be saying, so when do you think it'll be ready? Okay, how about February 10th? That's when we're going to start. Visitors can take pictures. It's hard to stop them, right? They walk in with their cell phones and they take pictures. I wouldn't fight it. But anyhow, broker compensation advisory is just a long advisory that most people don't read. This is the PRBS. And notice it says offers are not necessarily confidential. Buyer and a seller or listing agent may disclose the existence, terms, or condition of buyer's offers to other interested buyers and agents, unless there's a non-disclosure agreement, which there virtually never is. Fair housing, that's somewhat explanatory. Seller advisory. One of the things that I point out to sellers is the discussion, which is here someplace under pre-marketing. This is why we ought to get inspections and reports before we put it on the market. Consumer privacy. Okay. So the other form that I just wanted to mention is, oops, the realtor, let me see what happened to it. Acknowledgement and disclosure. So this gets triggered in a couple of ways. First of all, if there's a referral fee that you're paying to another agent, you're supposed to disclose that. Now, some of this I think is silly because B1 says you are a realtor and you're a member of the whatever your local association is, or you're not a realtor. And they think the big difference is the code of ethics. My question is, if you are not a realtor, how did you get a copy of this form anyhow to have people fill out? Because this is published by the Association of Realtors. The other thing, however, is other disclosures. Are you being compensated from other sources? Right? Is there a housing provider or landlord? Who else is paying you? But this is the part that I wanted to just point out because it's a really common question. What if the listing agent is related to the seller? What if the buyer's agent is related to the buyer? Aren't you supposed to disclose that? Now, I've had many agents say that has to be in the purchase agreement. If it's not, it's a violation of the law. No. The National Association of Realtors Code of Ethics say that you're supposed to disclose a personal relationship you have with a client, but it doesn't say where. It technically could be done in an email. It could be done in a text message. This is my cousin, right? But in order to clear it up, they've added it to this form. And it says, I am disclosing that I am selling or leasing property or whatever on behalf of yourself, a member of your immediate family, the brokerage firm identified below or anybody from it, an entity which I or my immediate family have a legal interest, other person related by blood or marriage, any person with whom I have a special relationship. Now, the real reason for this discussion is, let's say I've listed a house and I present an offer, and the offer is from Susan Wilson. Right, and the seller accepts the offer, and then at some point in the transaction, the seller meets the buyer and is chatting with the buyer about, oh, how did you hear about the property? And Susan Wilson says, oh, my uncle Mike told me about it. Now the seller's like, uncle? He never mentioned that to me, that you were a blood relative. Gee, I wonder why that slipped his mind. And you see, the potential for mischief is I call the niece up and I say, look, this is a really good deal. Make a low offer. I'm going to tell them it's the best they're going to get. You're going to get the house. Remember, my birthday is in June. Right? Remember that. Right? And so in that situation, we're supposed to disclose because we have a potential conflict of interest. Now, if the niece is the seller and I'm the uncle, well, I already have a fiduciary duty to do the best job possible for the seller. And the fact that it's a relative doesn't actually diminish that in any way, right? It doesn't, how does that affect the buyer that they should already know I'm on the seller's side? And the same thing is true if you're representing a buyer. The idea wasn't that you already have a fiduciary duty to the buyer. But we still have the NAR Code of Ethics that say you're supposed to disclose it. Where do you disclose it? Well, now they put it in a form. So there isn't this question, should it be in the contract? Agents write in, in the MLS that the agent is related to the seller, or they write in the purchase agreement, the buyer's agent is related to the buyer. We don't do that anymore. We just use the RAD form and go to 3B, and we check the right boxes. And then there's the referral fee, which is in C. I'm getting paid a referral fee, or I'm paying a referral fee, to whom and how much, and we sign the form. One last thing. I know I'm running a little bit over, but if you weren't aware that I did this, you have never been to one of my classes before. Let me just close this out. And that's not it. Someplace. It's here. All right. So the part of this that I wanted, this sort of gives you an explanation. There is a section that I didn't really go through, but it's near the end that talks about digitally altered photographs. And there's a section here about new digitally altered images, disclosure AB 723, and what's changed. It's also a section in the Business and Professions Code now. And a digitally altered image is any image where you have virtual staging, you remove furniture, you remove garbage, you painted the walls, you had a nice view out the back window, you've removed power lines and garbage cans and junker cars, and you do all that. Then you have to disclose in the MLS that this is a digitally altered photograph, and you have to have a link to the original photograph that has not been digitally altered. Easiest way to do that is you could create a QR code and you can stick it on each of the digital photographs before you upload them into the MLS, and somebody can scan the QR code and then they can see what the original looked like. You can crop. You can correct the brightness or colors. Essentially, they let you do things that you could do with an old-fashioned camera. You could sharpen it. You could make some lighting changes. But, you can't do any of this other stuff, particularly removing garbage and having it virtually staged. You have to disclose, you have to give a link or QR code, or you have to display both images. That's a pain. The easiest way to do this is to Google Drive. You create a folder that has the images. You make it available to anybody for viewing. You copy the URL. You go to one of the many QR code generators. You generate a QR code, and you embed that in the photographs that you put on the MLS with a little message that says, see the original, click here, right? What else? Any questions about what did we do? Any?
Michael, this morning, on the C.A.R call, sorry if I'm too loud, they were saying, and they were showing specifically that both pictures would be put on wherever it was being displayed, and one would show the original and one would be labeled original and one would be labeled altered.
So
I don't know if that's really necessary, but they said there are still issues with what agents are doing.
I'll bet. So who actually controls this? And the answer is it's the MLS.
I was going to say the MLS.
Yeah, it's the MLS. So C.A.R, which is the Silicon Valley Association of Realtors, for those of you who don't know, can talk about it. But the multiple listing service is the one that actually has the rules, and they change. They're a little bit different, right? C.A.R MLS and MetroList and MLS listings, they oftentimes have slightly different rules. So your MLS undoubtedly has published what they want, and you would follow those regulations. I'm sure they've had seminars, webinars where they discuss it. But that's up to the MLS.
Thank you for the clarity. That's good to know, so that if I'm doing an out of area listing, I look to see what that MLS, what their rules are. Okay, thank you.
And what is an interesting question, to which I don't know exactly, but I can guess the answer. What about data share? So if I put in a listing in MLS listings, an MLS listing says all you need is a QR code and a statement that this is a digitally altered image, see original, and there's a QR code. What that's going to be syndicated to MetroList and Barris, San Francisco, Bridge, C.A.R MLS, San Diego, the MLS, which is the big Los Angeles MLS. Now, those MLSs might have different rules. right? But it's a data feed. And does CRMLS really have control over MLS listings? I doubt it. But, what are they going to do? Not syndicated. They have bots that go and check these things. But you understand, I don't think they've really figured all that out yet. Right? The minimum, what EXP requires is that you follow what the Business and Professions Code and the Civil Code say you have to do. And then you should follow what your MLS says because they'll kick you out or fine you if you don't. But they don't impose additional requirements. Any other questions, comments? Was that fun?
Michael,
Oh,
I do have a question on the RAD. If you're doing something, let's say I received a referral. I have a specific situation. And with the other agent, what I do when I get a referral is I do the staging. I don't pay for staging, but anyway, I make sure the house is prepared and that it looks excellent, and maybe new bedding and the photographer and all the costs that go in. So what I do is the commission is 25% net. Okay. So that in essence, all the expense, well, it can come up to thousands of dollars. So I think it's fair. And I do, I think a nice referral fee. So I'm just asking, where does that go on RAD? Because on the RAD form, it says you're paying to this other broker, the broker's name, and then it says percentage.
yeah.
Where could you put that? Would you use a RAD addendum, or how would you stipulate that?
I would just put in the percentage. The the referral, assuming you're using the California Association of Realtors broker-to-broker referral form, is where it would have those specifics.
I was doing that, but I understand that the RAD is now, and the RAD asks for that information, but it doesn't give you a place for other.
I understand what you're saying. What my point is, do you really have to be that specific on the RAD form, right? Or do you simply have to say that you're paying a referral fee to somebody else and 25%? Now, personally, I think that it would be, why would I want to get into that level of detail that I'm paying them 25% after expenses, right? I'm simply, what RAD wants is for me to tell the client that I'm paying a referral fee. But you're
Perfect. So
correct.
I
There
see
is
what
no
you're
spot
saying.
there to add it in. They don't have other terms. The C.A.R. has been eliminating a lot of the other terms because of the crazy stuff that agents tend to write in. That would be useful maybe, but I think it's too much, too specific. The broker-to-broker referral agreement would say, I'm paying you 25% of my net, not the gross. That's fine. There's room to write that in there, but on here, the RAD, we would just say 25%.
Thanks, Michael. I appreciate it. You're always so smart on all this stuff. Okay.
Well, that was nice. Any other questions, comments, criticisms, suggestions for the next class? I've been getting a lot of people asking me about rentals. How do you list a rental? What do you do when you've listed a rental? What do you do when you're filling out the lease agreement? And just for funsies, I was thinking about doing that. Unless, would you show up? I don't know. I see a thumb up. It's better than some of the gestures I get when I'm doing that. So one person will be there. That's good to know. On how not to make an offer contingent on the sale of property. Badal, do you want to do that next week?
Yeah, let's do that.
Okay. So Badal and I have a presentation on how to sell a house, buy a house without the sale of property contingencies on either side. And we'll do that next week. That's also an important one. This is common with move-up buyers. It'll be fun. We'll go through all the different options you have. My general feeling is we don't want to make offers. We don't want to sell contingent upon the finding the buyer. We don't want to buy contingent upon the sale. We don't want to do that. You're leaving a lot of money on the table. We'll do that next week. All right? Sound good at all?
Great.
All right.
Yeah, yes, sir.
And then rental
Great.
listings later. See, I take requests. All right. Any other questions? I'm calling it a day then. Goodbye, everybody. Have a wonderful time.
Great.
Bye.
Bye.